Thank you very much and good morning. What I would like to do in the next 15 minutes or so is give a very brief overview of how in the last 15 years Scotland has moved from a jurisdiction which really had no proper legal framework to address issues affecting people with dementia to one where policy and legislation is explicitly rooted in a human rights approach. Obviously, I've got a minute a year, so that doesn't give me very much time to go over quite a rich story, but I will try and point out some of the highlights, and particularly some of the ways in which a coalition of the voluntary sector, government, the policy community and professional organisations have managed to drive what I think has been a really fundamental shift, both in the approach to dementia and how dementia is then dealt with in care and treatment. And I no doubt other countries are on similar journeys, but I hope there may be some lessons for other people in how that approach has manifested itself over the last 15 years. And I think particularly in the light of the Glasgow Declaration yesterday, it may give us some clues as to how that can be taken forward over the coming years. When I started working in this field in the 1990s, I think it's probably fair to say that, so far as the law was concerned, people with dementia didn't really exist. There was no adequate framework for issues, particularly around how does one take decisions on behalf of a person who may have lost the ability to make financial and welfare decisions for themselves or whose ability may be significantly impaired. There were procedures, ancient procedures, such as the curator bonus, a Latin term for a person who was able to manage the finances of an incapacitated adult. But they were incredibly expensive, incredibly cumbersome. Often more money was spent on the fees for the lawyers operating the curator bonus system than was actually spent on the welfare of the adult with dementia. So in the 1990s, the Scottish Law Commission came up with a major report on the legal framework for people whose legal capacity was impaired or absent. And there was a major campaign involving Alzheimer Scotland, involving other organisations for learning, disability and mental health, involving professional organisations. And that led, a year after Scotland's new Parliament, to the Adults with Incapacity Scotland Act of 2000. And for its time, that was a major and comprehensive piece of law reform. What the Act did was establish a range of processes to allow people to make what you would call proxy decisions. So that included a process of guardianship, a process to authorise people to appoint a welfare attorney on their behalf before they became too unwell to look after their own affairs, and with protective oversight by my organisation, the Mental Welfare Commission, and a public guardian to oversee financial management of people's affairs. But as important as the processes were, the principles underlying the legislation, and I've put some of these on the slide, that there should be no intervention in the life of a person unless there could be a benefit shown for that person. That whenever there was any legal intervention in that person's ability to take decisions, the least restrictive alternative needed to be used, and one should always take account of the wishes of that person and maximise the person's own participation in their own affairs. So although the Act was there, in a sense, the whole purpose of the Act was to authorise somebody else to take decisions on behalf of a person with incapacity. It sought to maximise the principles of voluntary care and minimise the use of formal interventions. The Act has proved to be extremely popular. There are many, many thousands of powers of attorney in existence now, and in the last 4 years there's been a 58% increase in the use of welfare guardianship. In some ways that popularity is beginning to produce strains in the system, and there are emerging concerns from a human rights perspective that, for example, too many guardianship orders are for too long. They may be indefinite rather than time limited. It's not clear how far the Act can be used to justify measures such as physical restraint. And although there is a court process to ensure that the rights of the person with dementia are protected, the orders are usually unopposed, and so there's a danger that, particularly as the numbers of orders increase, the level of supervision is going to be inadequate. The next, if I can get this thing to click. Next big change happened in 2003, and this is new legislation primarily concerned with compulsory treatment for mental disorders, so mostly directed at people with mental illness rather than dementia as such. But it was very important that it picked up on the principles of the adults with incapacity and actually extended those. There are a set of principles known in Scotland as the Millen principles, which included many of the adults with incapacity principles, but also broadened them to include concepts around equal treatment, participation, and particularly the idea of reciprocity. That if the state was interfering with your autonomy or was taking some kind of formal measure that took over your autonomy, the state had a duty to provide appropriate services and care. And I think in terms of the human rights journey, this piece of legislation was the first time where a direct link had been made between a legal framework for decision-making and rights of people to appropriate care. One of the other things that was important about the process of this legislation was that for the first time, service users were directly involved in its implementation. I mean, I have to say, although I was quite proud of being involved with the Adults with Incapacity Act 2000, I don't think I met a single person with dementia in all the time I was involved in that campaign. The Millen Committee, which led to the 2003 Act, had a mental health service user and a carer on the committee and consulted very, very extensively with service users. So that principle of the voice of the user being fundamental to policy and legislation was beginning to become established. And also some specific rights which we would now see as human rights were included in the bill, such as the right to access advocacy, and it was made clear that all people with mental health problems, learning disabilities or dementia should have a right to access advocacy when they need it, and a right to expect local authorities to provide an appropriate range of services. So a very, very powerful piece of legislation. As with the 2000 Act, it's difficult to keep some of these principles in an age of austerity, and I guess this is something that everybody in the room will recognise. So we do worry that some of the financial constraints that government and services are under are starting to eat away at the careful balance of rights and powers in the Act, but it's still an Act that I think we can be very proud of. Turning specifically to dementia policy, I want to say a little bit about the Charter of Rights for People with Dementia, which was created in 2009. And this was really a watershed around the policy and care framework for people with dementia. It was developed largely by Alzheimer Scotland. There was a widespread consultation with people with dementia, with carers and families, and with other organisations. It was very important in the way that it was endorsed by a range of interested parties, including members of the Scottish Parliament. So it started to bring in MSPs and legislators into this rights discourse. And it set out 15 specific rights that people with dementia should be able to claim using what's called the panel framework. I think Gráinne will say a little bit about this as well. This is a way of thinking about human rights which is very, very helpful in terms of 5 key headings of participation, accountability, non-discrimination and equality, empowerment and legality. And that gives you a way of addressing a range of human rights perspectives in policy and legislation. And that 2009 Charter directly informed Scotland's first and second national dementia strategies. Those of you who were here last night will have heard Jeff Huggins speak about how important those strategies were to the development of care in Scotland. The first strategy with a focus on developing standards of care, better support following diagnosis and better discharge planning. And the current strategy with the development of the notion of a dementia services coordinator with an aim to promote best practice in advanced care planning and in the assessment of capacity and in the reduction of the inappropriate use of psychoactive medication. And I'll say a little bit more about that in a moment. So where should I point this? this going somewhere? Okay. So up to now I've talked really about, I suppose, how a human rights approach has informed specific policies around dementia and related forms of mental illness and mental health problem. What I'd like to go on to now is how that has become universalised through the Scottish National Action Plan for Human Rights. This is not a dementia plan, this is an action plan which has been devised by the Scottish Human Rights Commission through a 4-year process which involved government, the public and the voluntary sectors. And it is intended to coordinate a range of actions across the whole of public services, so across housing, across employment, across care and so on. And within the Human Rights Action Plan, there's a specific work programme being developed under a Human Rights Action Group on Health and Social Care, which is developing human rights-focused care standards, looking to codify and expand the rights of carers, developing human rights principles for self-directed support and independent living. And there's a broader focus on empowerment, about increasing people's understanding of human rights and increasing their ability to participate in decisions. So from the point of view of this journey, this is the first time I think that dementia and the related conditions are being seen as part of a wider human rights narrative, and not as an afterthought. Dementia was actually a front runner. One of the specific things that are mentioned as good practice and as a beacon for other areas to follow in the action plan is the Charter of Rights for people with dementia. So there is an opportunity for the dementia movement really to show the way for other kind of human rights actions across public services and public policy. So that's a great story, and I think we've come a long way from, as a time when people with dementia didn't really exist in law to a time where they are embedded in the policy framework, both as participants in that framework and with a particular focus on their needs and their perspectives. But human rights is a constantly evolving framework, and we could not say that what we have in Scotland is good for all time or is even adequate for now. There are two things happened in the last few months which pose really huge challenges for us in terms of how we conceptualise human rights. One is a decision of the UK Supreme Court, and this concerns when it can be said that somebody has been deprived of their liberty so that it would require some kind of judicial authority under the European Convention before that liberty can be taken away from them. And the Supreme Court, in a case called Cheshire West, has greatly expanded the conception of what is a deprivation of liberty, so that people who may be in a care setting, which is by far the best setting that could be devised for them, could be homely, could be personalised, if they're not able to leave and if they're under continuous supervision, the UK Supreme Court has said they've been deprived of their liberty. So we now need to think about how do we ensure that that can be legally authorised without creating a massive overbearing legal framework, which in a sense rubber stamps deprivation of liberty but doesn't protect people. And at the same time, the UN Convention on the Rights of People with Disabilities is challenging the whole notion of substituted decision-making. The UN Committee has said that the new paradigm has to be supported decision-making and that substituted decision-making should be done away with. Now, I have some problems conceptually with that, but it's certainly a challenge just to think about how do we move from simply authorising somebody else to act on behalf of a person with dementia to providing better support to assist that person with dementia to maximise their own autonomy. And we need to find a middle way between the pressures of these two calls, either to have more judicial authority over people or to have none at all. And the other challenge is bad things still happen. My organisation, the Mental Welfare Commission, last year visited all the continuing care wards for people with dementia in Scotland, and we found some great things. We found some really good practice, and we also found some terrible things, and things that are not difficult to identify as bad. This wasn't us being terribly clever. This was about things like people being on multiple cocktails of psychoactive medication. It's about people not having access to the outdoors. It's about people not having any kind of meaningful day activity. Now, the government has accepted the findings of that report and is acting on it, but I think it highlights that however good our human rights framework is, we will still need protective mechanisms which actually ensure that somebody is looking out for people with dementia in whatever setting they're living in. So, in conclusion, the lessons I would draw from this are that a rights-based approach, the kind of thing you were seeing in the Glasgow Declaration yesterday, is a real driver for change, not just to the legislative framework, but actually to transform care, treatment and support. But in order for that to be effective and meaningful, it needs to be grounded in the participation of people with dementia, their families and their organisations, and you need to think about how you develop coalitions with policymakers and legislators to maximise the impact of the human rights approach. Thank you very much.
Okay, thank you, Colin. We have time for 1-2 questions, maybe. Any questions from the floor? Okay, there's Mark there. Do you have a microphone, please? You have to shout, Mark. You're a big guy anyway.
Yeah, I was just wondering if people with dementia have a right on services, but they're not available. What is happening? Is it possible to enforce this right towards the government?
That's a very good question. I think the rights to services that are in the 2003 Act, I mean, they are different from previous legislation in that legislation typically just provides a general duty to provide a service such as support. The 2003 Act does talk about people having a right to services. To be honest, I think at the moment it's probably not it's not being judicially enforced in the sense that the level of that service can be defined by a court. Advocacy is an example. There's a clear right of access to advocacy. Nobody, as far as I know, has ever gone to court and been able to say, I didn't get my advocate, therefore, that I would be entitled to damages. So it's probably not drafted in a way which makes it easy individually to take action. But it is one of the things that we want to think about is how do we build in accountability into the system? So in terms of how do we monitor the performance of local authorities, for example, how do we make sure that there are measures to demonstrate that they are providing an adequate level of services to fulfil these obligations? And I think that's probably the next step in the process.
Okay, another question over there. There's the mic there, over there, in the middle of the floor.
Thank you. Toby Williamson from the Mental Health Foundation. You mentioned that you had some issues with the conceptualisation around the Convention on the Rights of Persons with Disabilities, particularly around perhaps people with dementia. And as you know, the UK government is having to report its compliance with CRPD next year, and we've been doing some work with the Ministry of Justice in London, in England, about this. So I wonder whether you could say a little bit more about your concerns or issues with the CRPD.
I mean, I think my concern is that it's not so much with the convention, but with the comment of the committee, the general comment of the committee, which essentially says that there should be no such thing as legal incapacity, and all substituted decision-making should be done away with, and it should all be supported decision-making. So that is asserting that everybody with the right support can make legally competent decisions. Now, I mean, I think that's just not the case, and actually, I would argue, is potentially discriminatory against people with more severe disabilities. So, although I think the committee is absolutely right to challenge us to think about how to make supported decision-making more embedded in practice and more real for people, I just think it's denying reality to say that we can have a system where everybody can make their own decisions, because I think that leaves some people very vulnerable to exploitation.
Okay, the last question, please. Can we have the mic here?
My name's Margaret. I just wondered, for the training of people with the Mental Capacity Act, because there are actually many different models of dementia, as to the multidisciplinary teams. So how can I, as a carer, actually be sure that the or even as a nurse working in the field, that the multidisciplinary teams have an understanding or a common understanding, if there is one, of actually what dementia is? Is it a medical model? Is it dialectical model? Is it the old age model? What model is it? And is it done in 5 minutes? Or is it done appropriately? I'd like to be, reassured that it's actually done appropriately and what training there is available.
I think the points you make about training and shared understanding are really, really important. And as we go around services, we do find a very mixed picture that in some services, people aren't really clear about even what the law is and what it requires of them. And so particularly perhaps people who, if you're a consultant psychiatrist, you probably do know a bit about it, but if you're a GP or, a home support worker, that may be less so. So I think there is a responsibility on organisations like ours to do more to spread shared understanding of the principles of the legislation. But also your wider point about an understanding of dementia, I think one of the things that Jeff talked about yesterday in Scotland is around the integration of health and social care. And I would hope that by bringing these services together, we develop a better shared understanding of the approach that we're taking to dementia and as the different ways of thinking about it, moving away just from a medical model to a wider understanding of dementia. But I think that's going to be a long process.